case which is Legrand case. And if you look at this Legrand case, you will find that this was the case between United States and Germany. And what happened that Germany sued United States before International Court of Justice. And this was decided by ICJ in 2001. So this was just in the turn of the century. 2001, this case was decided by International Court of Justice. And what happened that Germany, Rajneesh, are you showing your hand? Okay, so yeah, so please,
Hello.
Yeah. You were showing your hands?
No, not.
Okay.
No,
Okay.
not now. Sir. Initially, when you asked whether somebody has read the case or not,
Okay.
Against that, I put up my hand.
All right. Thank you. So you can now mute yourself and listen to the, yeah, thank you. So what I was telling you that Germany instituted the proceedings before International Court of Justice. And you know what? Germany contended before the court that US had violated an obligation. And what was that obligation? The obligation in question was the obligation contained in Vienna Convention on Consular Relations. This is a different kind of treaty which will tell you that there are different officials, and those officials are consuls, diplomats. So this consul, who are the consuls? Consuls are the agents of the state who represent one state in the other state. And technically, I will tell you the definition when we will discuss ambassadors and consuls' rights and privileges in topic number 6. So at this moment of time, what I will tell you a little bit about that convention, which deals with the rights and obligations of countries which have signed this convention, and which gives rights to the countries that how they will conduct themselves when their national is arrested in some other country. Then what is the procedure which is given in Vienna Convention on Consular Relation is that if a national of country A is arrested in country B, and if both A and B are parties to this Vienna Convention on Consular Relations of 1963, now in that case, what will happen that country B has the duty to tell the person whom that country arrested that, look, you have a right to be represented. And if you are having any problem, you can notify your state that you are arrested and you should be given help. And then the state will decide that whether to give help to the person who is arrested in that very country or not. But this is the duty of country B, that you have to inform the right of every detained person who is not its own national. So this is the right and duty which is mentioned in the Vienna Convention on Consular Relations. And Germany contended before International Court of Justice that United States breached this obligation. And how? What were the facts in this case? You know, in the United States, what happened? That a bank robbery was committed. In the 80s, a bank robbery was committed. And who were those people who were involved in the bank robbery? Those two people were Legrand brothers. One was Walter Legrand, another was Carl Legrand. These two brothers were involved in the bank robbery in a state of United States, which is Arizona. Arizona, you might have, this is a state which is kind of, having, there was a time when it used to have lot many bushes and cactus and these kind of, it was full of, jungle and forests. Even today, you might have heard that in Arizona state, there is a huge dam which is constructed near a very good natural place, conservation, which is Hoover Dam. So I have been to Hoover Dam, and it was a little bit sunny during those years. So it was very hot in the month of May. Yeah. So what I was telling you, that in the state of Arizona, in the 80s, these two brothers committed bank robbery, and United States public enforcement authorities, they arrested these two brothers, and after the court proceedings came to an end, these two brothers were to be hanged, and they were to be given capital punishment, because it was not a case of only bank robbery, but it was also a case of murder of the manager of the bank who was there on duty on that day. And there was also serious injury which was inflicted on other bank employee on that day. So what happened, that these two brothers were to be hanged. And when this news were flashed all over the world, including Germany, Germany came to know that these two brothers were of German nationalities. And how was it so? Now, these two brothers were adopted by a US parent, by a US household. These two brothers were adopted, but they were not given citizenship, because they might have obtained citizenship after 18, 19 years. But at the time of getting 18 years of age, sometimes people, they are not in a good company, and these two brothers were not in good companies perhaps. And so what happened, that the parents might have thought that, okay, let us wait for some time. And in the meanwhile, they committed bank robbery. And therefore, it was wise on the part of their parents that not to give US citizenship on them. So what happened, that at the time of arrest of these two brothers, even the US authorities, they did not know that they are not US citizens. They thought that because they are the children of parents of US, therefore they might be US citizens. So they did not inform anything to these Legrand brothers. And what happened, that they were kept in prison, and thereafter they were attending the proceedings in the court, and finally a day came when they were to be hanged. Now, at that moment of time, just before they were to be hanged, maybe 1 month before, Germany went to International Court of Justice and immediately prayed for stopping of the execution of Legrand brothers, because it was a breach, and that was a serious breach committed by United States, that it violated Vienna Convention on Consular Relation, which provided every state to inform the person who was detained by its authorities that they had got the right to defend themselves in the court. And because they were denied that right, even they were denied the right to get, information. And therefore, what happened, that Germany contended before International Court of Justice that United States had breached Vienna Convention provisions. United States, on the other hand, if you look at the contention of United States was contending that, look, our authorities, they did not know at the time of arrest that, okay, they were German nationals. And therefore, our authorities, they did not inform, and they knew after a long time. And at that moment of time, the court proceedings were already going on, and whole trial, witnesses, everything were there. So it is very difficult for the court to again retract and then, go for review of the case. And therefore, United States said that, okay, because of this reason, we could not do it. And because they have committed a very serious crime in the United States, and therefore they should be hanged. United States, even today, they have the laws in many states that they could give capital punishment. Now, ICJ ruled that Vienna Convention obliges every country, which is a signatory, of course, that whoever is arrested and the person is a foreign national, the authorities are under a duty to inform the detainee that they have a right to notify their own consular office. And they can also pray that they should be given this defense, because they do not know, because they are in a foreign country, they do not know the local language. So sometimes, so this is why this Vienna Convention has given this kind of responsibility on the state to do this, that to defend. Nobody should be punished without any kind of defense. So this is how what happened, that International Court of Justice ruled that there was a breach of obligation by the United States. Even when the United States was saying that we came to know about the nationality of these two brothers after a long time, even then the court said, no, this was the duty, because you must have known it at the time of arrest, and this is the duty which is provided by the Vienna Convention on Consular Relations. And thereafter the court ordered provisional measures, and this provisional measure order was given by the court perhaps in 1999, if I am not wrong. This was yes, 1999. This provisional order was rendered by the court in the year 1999, because that was the year when these two brothers were to be hanged. And you know what happened, that these brothers, they were in prison, they were to be hanged. ICJ provisional order came, and the order was that there should be review of the whole court proceedings, and at least the capital punishment should be stopped, because German law does not allow capital punishment. And therefore what Germany was contending, that at least there should be a stop on the capital punishment. Now what happened, that this order, provisional orders of ICJ, that was to be transmitted to the governor of Arizona, and that was also given to the governor of Arizona in due course of time, but it was very late. The day when he was to be hanged, it reached the governor of Arizona, and then governor of Arizona said that it's not easy to stop the hanging of these two brothers, and ultimately they were hanged. Then Germany again came to ICJ praying to the court that you also order that there was a breach of obligation by United States, that they did not observe your provisional orders measure. And then the court ruled in this case, if you look at this Legrand case, the court ruled that there was a breach of the obligation. And what happened, that the United States was contending before the court when this matter came up, and this matter was going to be heard before ICJ. The Council of US was saying that there is no settled jurisprudence, that provisional order measures must be implemented. And this is like a binding kind of judgment. So it was just a provisional measure, and we thought that, okay, this may not be such kind of order which must be implemented right now. But the court said that Article 41 of the Statute of International Court of Justice, which empowers the International Court of Justice to order provisional measures. The court ruled that even the order which is coming after Article 41 of the statute of ICJ, that order is also binding on the country concerned. And therefore, what happened that the court ruled that there was a breach of international obligation. And even there, US was held responsible. So you see that if you look at this case, you'll find that US was held responsible in this case because it had committed breach of international obligation. And as I told you, now we have ILC draft code of 2001, Article 2 of ILC draft code very explicitly says that if there is a breach of any international obligation taken up by the state may be held responsible, right? So there is an internationally wrongful act of a state when it constitutes a breach of international obligation of the state. So this was how Legrand brothers case was decided. And sometimes I will also refer to Legrand case when I will take up the next topic, which is what happens after this question is decided by the court that, okay, there is a breach of international obligation. What is the next step? So this is the next thing that we are going to discuss. If you have any questions till now, please show your hands and then you can unmute yourself. Yes, Rajneesh.
Yes, sir. I just want to know whether there is any difference between consul and embassy.
Yeah, there is a difference, and I will discuss this difference when we will take up topic number 6. What is the difference between envoys, consuls, and other agents which are appointed by the country?
Right, sir. Thank you.
But at this moment of time, I can tell you that consul are those agents of the state who are given the power to conduct the normal business transactions, like looking after the business interest of the country in other country, and sometimes also looking for visa, how many people have come, and what are the facilities which should be given to the nationals of that very state. Okay, Rajneesh? All right.
Hello. Sir, can you provide us with any example of the consul in India? For example, consul of US, like we have one embassy of any country. Apart from embassies, can you provide with any example of a consul which are there in India or any country, for
So
example?
you see, the embassy of any country have different officials. So somebody will be called ambassador, somebody will be called consuls, somebody will be called some other kind of agents which are doing some activities related to that very state. Basically, there are two broad categories of the officials in an embassy. First is ambassadors, or persons who are political representatives of state, and others are consuls who are given
Right,
a
sir.
specific task of looking after the business interest of the countries.
So means can we say that the consul come under the embassy only,
Consuls? What?
or consul is an agent of embassy basically?
Not agent of embassy, but they are agents of state, country.
For state they are agents, but for embassy they are not agents. They are separate than
They
the
are all
embassy,
officials of an
or
embassy. So
different,
they are all
distinct from
officials
the.
of the state in the embassy.
Okay, right. Got it.
Okay, thank you. So, uh, yeah. So now what we are going to take up, another part of state responsibility, which is the important part for any advocate, because when you become an advocate tomorrow, your client will be more interested in getting compensation or getting some kind of relief, So just giving an order by the International Court of Justice that, okay, there is a breach of international obligation will not satisfy your client. So the next important thing which your client specifically which is interested in is that question of, what will be the relief which is awarded by the court. And as a counsel, you must look at the provisions of International Law Commission draft code. And if you look at the ILC draft code, you'll find that in ILC draft code, a full chapter is there on, the word which is called reparation. What is that? Reparation. There is a term which is used in international law, which is reparation. It's not, what we call in law of torts damages. So although it is damages, but in international law, you have to use a different term for it. And what you have to use? You have to use the term reparation. So the client will be interested in the reparation. What is the reparation which is given by the court? So is there any provision on reparation? But first of all, we must know that what is the meaning of reparation and where is it found in International Law Commission draft code. In International Law Commission draft code, you'll find in Article 31. And if you look at Article 31 of ILC draft code, it says that the responsible state is under an obligation. The responsible state is under an obligation to make full reparation for the injury caused by the internationally wrongful act. Okay. So what Article 31 says? That there is further obligation on any other country. Not only there is an obligation to abide by the obligations contained in the treaty, but also there is further obligation, according to Article 31, to make full reparation for the injury caused by the internationally wrongful act. And then paragraph 2 of Article 31 says that the word injury in paragraph 1, injury caused was there. These were the words in paragraph 1. In paragraph 2, the word injury is made clear. The meaning of the word injury is made clear. What is the meaning of the word injury? It says that injury includes any damage, whether material or moral. You see, it's not only material damage which is important. There can be even moral damage caused. So paragraph 2 says injury includes any damage, whether material or moral, caused by the internationally wrongful act of a state. What does it mean? It means that the ambit of reparation in international law is wider. It's not limited only to the economic consequences of a wrongful, internationally wrongful act, but it is also going up to the moral damages, moral injury which is caused. So sometimes some state might feel that, okay, the conduct in question is a contempt. This is a moral injury. The contempt of the reputation of another state. So this may become a moral injury. And I will come to therefore I will come to now the different forms of reparation. What will be the exact form of reparation that you will ask from the court that you must know as a counsel of a country? What exact form of reparation? Because reparation, the form, therefore, because now according to Article 31, you might now have known that the ambit of the word reparation is wider. So what are the different forms of reparation that we are now going to discuss? And we will discuss in that way. We will also discuss some of the cases. Although we have discussed many cases, so I will sometimes just relate some specific point of a case, and then we will also relate it to the ILC draft code. Now, if you look at the ILC draft code, it says in Article 34, it says that there are different forms of reparation. And as a student of Law Center 2, how many forms of reparation you must know? You must know not more than 3, 4, or 5. So 5 bole to muthi, I should not go more than that. The first form of reparation according to Article 34 is restitution. Restitution. I will come to restitution in a little while, but I will also tell you what is the another form of reparation. The another form of reparation is called indemnity. The third form of reparation is called satisfaction. And the fourth form of reparation is called cessation. And the fifth form of reparation is called guarantee against non-repetition. These are the 5 forms of reparation. Sometimes in your examination, the tail of the question, or sometimes in a short note, this question may be asked that what do you mean by reparation and what are the different forms of reparation? Give some examples. So this is how, because I told you as a counsel of any state, your client will be more interested in a reparation point. You must know what are the different forms of reparation. I told you 5 forms of reparation are there according to ILC draft. The first is, again I am repeating, the first is restitution, second is indemnity, third is satisfaction, fourth is cessation, and the fifth is guarantee against non-repetition, guarantee against repetition. Now, what I will tell you, that the first form of reparation is restitution. What is the meaning of restitution? Now, restitution is defined in Article 35 of ILC draft code. According to ILC draft code, restitution means re-establishing the situation which existed before the wrongful act was committed. Did you understand? Restitution means you are restored to the original position. This is called restitution. So after the wrongful act was committed, the position had changed. The position of a state might be changed. No? So restitution means to re-establish the same situation which existed before the breach of any obligation by the state. So Article 35 has made it very clear that restitution is the first form of reparation. And it also further says that restitution should be preferred and it should not be overlooked unless restitution is materially impossible. And second, it says that it does not provide a burden to the state, too much burden. It simply says it should not be a too much burden on the state. So it means that Article 35 of ILC Draft Code has made it very clear that reparation should be the first form of reparation. And so I ask sometimes my students that suppose some country, because in our country there are some places which are very attractive places, and the topmost place which is the most attractive one in our country is obviously Taj Mahal. And like suppose a person from a country came and say that when he went back to his country, he says that, okay, now this Taj Mahal is very beautiful. And then the country says, okay, like suppose, okay, this is a foreign revenue churner of that country. This place is a foreign revenue churner. And therefore, what the country decided, the country suppose decides to, bomb Taj Mahal. Now suppose in that case, if I tell my students, I give this example to my students that in that case, suppose if India takes up this cause before International Court of Justice and praying to the court that we just want what kind of compensation will you claim in the International Court of Justice if such kind of tourist spot is demolished or bombed? What kind of reparation is the most appropriate reparation? Anybody? You will want to get Taj Mahal back or what?
Yes, sir, to restore Taj Mahal back.
Okay. Yeah, of course. Because it's very difficult to have a new Taj Mahal. Many countries, they have tried to build their own Taj Mahals. When I was in US, I found that there is a replica of Taj Mahal in one state of US. Many people were telling me that replicas of Taj Mahal in France and other countries, they have been tried to be made, but they're not. They are not up to the mark. People say, okay, this is kind of replica, but Taj Mahal is different. Yeah, and that is the reality. What I was telling you, that restitution means to re-establish the situation. Taj Mahal cannot be built by any country today. Right? In that case, what will be the form of reparation? Then you will tell your client, okay, there is no possibility of having Taj Mahal back, so okay, no question of reparation. No. The second form of reparation is, therefore, which is mentioned in ILC draft code, is indemnity. Indemnity is called compensation. Article 36 of ILC draft code provides for next form of reparation, which is compensation. Which article did I tell you? Article 36. 3 into 2, 6. 36. Very easy. Article 36 of ILC draft code provides for compensation. And what does it say? That the state which is responsible for internationally wrongful act is under an obligation to compensate for the damage caused insofar as such damage is not made good by restitution. It means that every country is bound to provide compensation if restitution is not possible. And second part of Article 36, which is more important, is you must have a look at it. It says compensation shall cover any financially assessable damage, including loss of profits, insofar as it is established. What did you understand from second paragraph? Second paragraph says that any financially assessable damage, it means that there must be assessment of damage. If you cannot be able to assess the damage, it will be very difficult to get compensation. There must be assessment, and that assessment should not be in a vacuum. It should be financially assessable in monetary terms. Okay, this much of dollar, or this much of rupees, this much of millions of rupees, or this much of million of dollars. You must financially assess the extent of damage. And Article 36, paragraph 2 also provides for the loss of profits. And perhaps I will remind you of the principle of the breach of damages that you might have learned in the law of contract. In the law of contract, you might have learned in what was the case? It was the case in contract, was that Huxley or what? In that case, it was very clearly ruled by the court that if it is made known to the other party that if the other party will not perform its obligation, this much of profit will also be lost, then the client is also having the capacity to pray to the court to get the profits which the client has lost. So this is also there in the ILC draft code. In ILC draft code, Article 36, paragraph 2 says that if there is any loss of profits, a country can claim the loss of profits too. So very important. This is Article 36, and therefore any country which alleges that there is a breach of international obligation, it will have to first of all show that what is the extent of damage which is caused, and that damage must be financially assessable. So therefore there is a damage theory. It should not be simply a breach, but the breach should go further. If you again look back at Legrand case, what was one of the contention of Germany? That the provisional order measure was not observed by United States. But at the same time, Germany missed to also pray for any form of reparation. So what was the exact loss which was caused to Germany due to the non kind of enforcement of the provisional order measure of ICJ? So therefore the court, in one of the paragraph, if you look at the judgment which is given for you, we have edited the portion of the judgment, some of the portions of the judgment, but even then the portions which are there in your study material, in those portions also this very point is also mentioned, which says that if a damage is not concretely argued, properly argued by the counsel, that what is the extent of damage caused and what is the form of reparation that a country wants, the court will not further rule over that very point. And therefore, this question was left by the court, saying that, okay, there is a breach of international obligation in not observing or not enforcing the provisional order measure of ICJ, but then Germany has not specifically asked for what form of reparation it is interested in. So as a counsel for tomorrow, you must also be very clear that you must also pray. Suppose if you pray for any breach of international obligation to be decided by the court, you should also further pray that, okay, once you have decided that this is the breach of international obligation, then you should also decide that this is the amount of compensation, if you want compensation. Or if you want restitution, there should be restitution. So what I was telling you that Article 36 of the ILC draft code deals with the second form of compensation, second form of reparation, which is compensation. Now I'm going on to the third form of reparation, which is satisfaction. What is this satisfaction? Satisfaction, I have told you at the beginning that sometimes what happens that there is a moral injury caused. And therefore the proper way of reparation is satisfaction in that case. What is the meaning of satisfaction? Article 37 says that satisfaction may consist in an acknowledgement of the breach. You acknowledge the breach. This is also satisfaction. जैसे आपके पापा मम्मी आप जब कोई काम करते हो जो गलत है, तो पापा आपके कहते हैं कि आप मान लो बेटे बस. You know, ये मानना बहुत बड़ी बात है. आजकल लोग मानते नहीं हैं. हम करते हैं, गलती करते हैं, लेकिन मानते नहीं हैं. You see. So ये satisfy करती है बात. बड़े लोगों को या अपने दोस्तों को भी sometimes you do an act which offends your friend, तो friend तो नहीं लेगा ना आपसे पैसा, तो आप कैसे satisfy करोगे आप अपने friend? तो you should acknowledge that, okay, I have done it wrong. So this is very simple to understand in Article 37 of ILC draft code. Yes, Rajneesh, you're saying something. Rajneesh, are you saying something?
Hello?
Yeah, are you saying something?
No, sir, no.
Okay. Sorry. So
No issue,
I'm
no.
telling you that the third form of reparation is satisfaction. And satisfaction is an acknowledgement of the breach of an obligation. Second is expression of regret. You regret that, okay, I have done something wrong, and there was a time when people used to regret. In the like we go to the temple, and then what we do in front of the God, that, okay, God, save me because I have committed this wrong. Even if you do that, this shows that you are a good human being, because you have the sense that, okay, you have done something wrong and you want to regret. You see, or a formal apology. Satisfaction also has this component. You should render a formal apology, right? Now, you will not render a formal apology to the God. So what will you have to do? You will have to tender a formal apology to the state in question, if this is international law. So tendering a formal apology, I tell my students that there was one day when one of my students, he was a good officer, but still sometimes what happened that he was at one day he was not in a good mood, and I was taking attendance, and then he said, okay, sir, you give my attendance, although he was very late in the class, and in the mid of the class he raised his hand and says that, okay, give me attendance. I said, you have to wait wait after the class, I will give your attendance. He said, no, you give me attendance, I will forget. I said, okay, because you are disturbing the class, please wait. No, you give. I said, and then he was so much agitated, he came to my podium and then he took attendance register from me. And then he said that, okay, you give me. I said, no, I can't. And this was a scene. And then, I said to the whole class, I'm going because I can't continue in this way. So, these kind of episodes are sometimes, giving you. So what I said, and then the student after some time came to me saying that, sir, I committed a mistake. Privately, he told me, I committed a mistake. I said, okay, fine. At least you have now understood that you have committed a mistake. But will you tender an apology? See? So, and then he took some time, but then he tendered an apology. So you see, I was satisfied. I said, okay, I am satisfied. I'm not going to punish you more. So you just, okay, you tender an apology in front of the whole class. So you see, so sometimes, this is also in international law, what is another possibility is satisfaction. So satisfaction is tendering a formal apology or any other appropriate modality, right? So satisfaction is these kind of things, right? And so I also give example to my students in the class that suppose if India, you become the ambassador of India and then you are appointed in Pakistan and you are in Islamabad, and sometimes there is some incident which took place in Pakistan or in India, and then Pakistan government is so much annoyed with India's conduct that Pakistan calls the ambassador of India to Pakistan, and then he goes to meet the foreign minister, and then in front of the whole media, foreign minister slaps the ambassador of India. Now, what is the proper form of reparation in that case? The proper form of reparation in that case is satisfaction. If the foreign minister or if the Pakistan government will tender an apology, that may be satisfactory to the government of India. It will not be the appropriate form of reparation or appropriate form of action that, okay, then again the ambassador of Pakistan will be invited by the foreign minister of India, and then he will be also invited, and then he will be slapped. Yes. So these are the things that I was telling you today. And the last form of reparation is, the second last form of reparation is cessation. Cessation means stop. What do? You stop because you are committing a breach of international obligation. So you commit this act, and now after the court decides that, okay, you have committed the breach, you must be stopped. That is called cessation. Article 30 of ILC draft code says that the state responsible for the commission of internationally wrongful act is under an obligation to seize that act if it is continuing. So first thing is stop. And generally what happens that, even you remember that Kulbhushan Jadhav's case was going on in the International Court of Justice, and what India was praying to International Court of Justice that immediately render a decision by which Pakistan will be stopped to execute Kulbhushan Jadhav. And Kulbhushan Jadhav case I will discuss tomorrow in that context, or maybe I will leave it for you to study. So the thing is that Article 30, which deals with cessation, is another form of reparation. And finally, last form of reparation is non-repetition. Non-repetition is kind of guarantee. You take guarantee against repetition, right? So as a counsel of tomorrow, what you will have to finally pray to the court that, your lordship, the country must be said that you come with a bond of guarantee that you will not repeat it, right? So if this is also done, sometimes this is also one form of a reparation. But as a wise counsel, yeah, there was some problem. Yeah, yeah. So there was some problem. So just within 2 minutes, I am going to finish. What I was telling you that the last form of reparation is guarantee, which should be taken by the state to not to repeat it. What I was telling you that as a wise counsel of a state, you must suppose if you are not very clear that okay, what kind of appropriate reparation you must ask for from the court, then what you should do, that you should leave it to the court's discretion that what form of reparation actually you want to ask, and then court may provide compensation, but then court will ask you even if you are not if you have not mentioned it in the plaint, but the court will ask you that okay, what form of reparation will you be interested in. So this morning, what I have discussed, I have discussed some form of reparation, main forms of reparation, and some of the cases. When we meet next tomorrow, we will discuss. So perhaps all the cases I have covered, but I will discuss one more case, which is a very recent judgment. Two in fact, recent judgments. First is Nicaragua versus Costa Rica, which was a judgment rendered in 2018 by ICJ. Please read it. And second judgment I will discuss little bit will be Kulbhushan Jadhav judgment that was decided by ICJ in 2019. So these cases, we will continue to discuss these cases because these cases will also be important in topic number 8. So with this, I am now concluding. If you have any questions, please ask. Yeah, I am going to leave. And tomorrow, at what time we will be meeting? We will be meeting at 9. Is it fine? Or 10?
So I have a question. We're meeting at 9 tomorrow.
Yes,
That's the
good to
time.
see. Yeah, good to see you.
Yeah.
Good to hear
Sir,
it.
we have yes, I can hear you. We have a scheduled lecture at 9 tomorrow. But what I wanted to ask was, in the last week, there have been a lot of news reports that companies in the United States are suing the Chinese government for reparations over the coronavirus pandemic and their handling of it. Hello? Hello?
Yes, I am listening to you. Yeah.
Yes. There have been a lot of reports of companies suing the Chinese government for their handling of the coronavirus pandemic. There have also been conversations about whether countries together should sue China for their mishandling of the coronavirus pandemic, particularly of not disclosing the information early enough and trying to cover the information up.
Yes.
So in this case scenario, considering there is no per se particular breach of a treaty, can countries initiate action against China?
So the answer is provided in Article 2 of the ILC Draft Code. What is ILC Draft Code? Article 2.
1 second.
Article 2, paragraph B.
But sir, the question is that it per se is not a breach of something, right?
Okay. So then how will you go to ICJ?
So the reason I ask this question is because there are two things. Either you believe that truth and accountability are functions of the modern state and must be made public at all times, and over here China is complicit with regard to covering up the entire operation by not providing information early enough.
Yeah, but international law is very clear that unless there is a breach of a treaty, which that state has taken up, that state cannot be sued.
Okay.
It's very clear. Yeah. So there cannot be any question of taking up this matter before ICJ. Yeah, but then obviously this can be a kind of this can be a scenario where the diplomats and the countries, they themselves discuss these problems at the United Nations level and then try to solve it.
All right.
Okay. All right. So thank you so much for coming online today, and we will meet tomorrow at 9 or 10. 9 will be fine.
Yes, sir.
All right. Thank you so much. Have a
Sir,
good.
sir, I have one question.
Yes, Rajneesh.
Sir, no Ankush this side.
Oh, Ankush. Yes,
Yes,
Ankush.
sir.
Yeah.
Good
Sorry.
morning.
Yeah, Ankush. Tell me. Good morning.
Sir, is there any article for the fifth form of the reparation, which is not to repeat?
So same article 30. Please go. Same article has two.
Article 30. Okay. Okay. Thank you, sir.
Yeah. Thank you. Have a good day.
Okay.
Bye.
Hello.
Same to you, sir.
Yeah.
Thank you, and same to you, sir.
Yeah. Rajneesh.
I also have one question.
Yamini. Who is this?
Sir, Sushma this side.
Sushma. Yeah, Sushma. Tell me.
Sir, when we were discussing this chapter, which is relation between international law and municipal law, you
Yeah.
said that if there is conflict between international law and municipal law, so municipal law will prevail.
Yes.
So, sir, अगर कोई भी हमारी कंट्री में कोई भी ऐसा म्युनिसिपल लॉ है जो कि किसी भी तरीके से किसी ट्रीटी को पूरी तरीके से इफेक्ट में नहीं आने देता है, तो क्या इंटरनेशनल जो ऑर्गेनाइजेशन या जो भी है वो इंटरवीन कर सकते हैं हमारे म्युनिसिपल लॉ?
मतलब आप किस तरह का इंटरवेंशन कह रहे हो?
सर, जो अभी हमने केस पढ़ा है, इसमें जर्मनी ने जो सबमिशन करे थे उसमें एक सबमिशन ये भी था कि जो यूएसए है उनका जो म्युनिसिपल लॉ है वो अलाउ नहीं करता एपेलेंट्स को that appellant can't argue new defense if they did not raise in the original trial. जैसे कि उन ब्रदर्स ने ये क्लेम नहीं करा था उस समय ओरिजिनल ट्रायल में, ये नहीं बोला था कि वो जर्मनी से बिलोंग करते हैं, तो उनको आगे भी ये वो नहीं रख सकते थे क्योंकि उन्होंने ओरिजिनल ट्रायल में भी ये बात नहीं बोली थी. सो दिस इज समहाउ वायलेट्स द वीसीसीआर. बट उसके रिप्लाई में यूएस ने ये बोला कि डोमेस्टिक रूल टेक्स प्रेसिडेंस ओवर वीसीसीआर, सो आईसीजे हैज नो ज्यूरिडिक्शन. बट उसके रिप्लाई में आईसीजे अपहेल्ड्स द जर्मनी क्लेम एंड दे आस्क द यूएस टू इंश्योर दैट कि वो अपने म्युनिसिपल लॉ को मॉडिफाई करे ताकि तो वहां पे इंटरवीन करा आईसीजे ने उनके म्युनिसिपल लॉ में.
बहुत अच्छा. तुमने कहा ही नहीं कि मैंने केस पढ़ा है. अच्छा पढ़ा है तुमने. हेलो.
सो यस सर.
तुमने तो कुछ कहा ही नहीं कि मैंने इतने अच्छे से केस पढ़ा. नहीं, बहुत अच्छा तुमने केस पढ़ा है, and that's good that you have pointed out, and that's why when I was giving you the facts of this case, I was making it very clear to you that the authorities of US, they did not know at the beginning that they were from Germany, right? And every country have their own rule and laws, but then in this case you are right. ICJ said that because you are a party to Vienna Convention on Consular Relations, VCCR, and therefore you must now modify your laws. And what US had to do it. And I did not go into further aspects of this case, where Germany was also saying that you also satisfy Germany that you will not do these kind of acts in future. So
yes, and
yeah, So in that way, International Court of Justice can render a decision by which ICJ will say to the country in question